Welcome to War Story Wednesdays. Today I want to talk about a case that reads something like a pulp fiction novel, and it actually stars Bruce Willis. Mr. Willis had entered into an agreement with Benaroya Pictures to star in one of its movies and was going to make $8 million on the movie. Well, it turns out that Benaroya Pictures had a death wish and it breached the contract. And that is when Armageddon was unleashed. Now, being nobody's fool, Willis figured that Benaroya would file bankruptcy or somehow try to avoid the debt as a company. So Willis went after the last man standing, which happened to be Mike Benaroya, Benaroya Pictures president and chief executive officer, as its surrogate, as its alter ego. Willis decided he was going to go the whole 9 yards to get that $5 million out of Mike Benaroya. And Mike Benaroya must have had a sixth sense that Willis was going to come after him, because he imposed as many possible objections as one could in order to try to avoid paying for the liability of Benaroya Pictures. Now, a lot of you may not know what the alter ego doctrine is. When someone does business as a company, it is possible for a creditor of the company to attack the corporate shield, the formalities that make a company, and be able to impose liability upon the individual shareholders of a company. There are a dozen different criteria that have to be met in order to do that, or any sum of that dozen have to be met in order to do it. So one of those is that you don't honor the corporate formalities. You don't have bylaws and you don't have minutes of meetings. Another is that you commingle money. A further element is that you operate with the same telephone number for multiple companies out of the same business, and you use the same bank account to fund things from the same company. A fifth element would be if you're undercapitalized, if you don't have enough money in the company, and so you're spending your money to operate the company rather than the company having enough money to operate itself. And oftentimes, when a company is in trouble, it will keep capital out of the corporation, so that if there is a judgment like $5 million owed to Bruce Willis, the company can say, "Oh, I'm broke," and not have to pay. Mike Benaroya challenged Bruce Willis's efforts to pierce the corporate veil to get to him as opposed to Benaroya Pictures only. And the case revolved around whether or not this binding arbitration that Willis had in his contract with Benaroya Pictures could be imposed upon Mike Benaroya. And the court said no. The trial court allowed Willis to use the mandatory arbitration provision in his contract to bring Mike Benaroya into the case. The judgment went against Mike Benaroya, and then he went to the Court of Appeal. And the Court of Appeal said that since Mike Benaroya had not signed the arbitration agreement, he could not be bound by it and included in the arbitration with Benaroya Pictures. The rationale was that the court had to decide whether Mike Benaroya was the alter ego of Benaroya Pictures, not the arbitrator. So the lesson to be learned in this case is that if you have a binding arbitration provision, you have two choices. You can either first ask the court to designate the shareholder as the alter ego of the company that you're arbitrating with, or second, you can go ahead to the arbitration and then get a judgment, and then sue the shareholder as the alter ego. Maybe if Willis had done that, he could have given Mike Benaroya a yippee-ki-yay mother.